Hello. Good morning or good afternoon, depending upon where you are, everyone. From McMurray and Shuster, we are very happy to be with you to give our year-end predictions. And thank you for coming back a week later for these. I guess not quite a week. I had a little, actually, it's been a little over a week. I had a little bit of a scare. And before I even get started with our presentation today, I just wanted to put out a couple of things that I've learned in the last 2 weeks that have nothing to do with regulation, but everything to do with personal safety. I'll start with what happened at our office last Friday. Our office building had a carbon monoxide poisoning incident that landed two of our employees in the hospital last Friday. So I am highly recommending, if you do not have a carbon monoxide detector in your home or office, that you do that. We are in a building that is Class A building, but apparently a carbon monoxide detector was grandfathered out of being a requirement of the office building. So check about this type of thing, because luckily it was a Friday. We only had 6 employees working in the office. The rest were remote, or it could have been a really significant issue. And it took us several hours to figure out that we had a problem until we all spoke and shared that we were feeling nauseous and lightheaded and those types of things. So it was quite a scary thing. Get one if you don't have one. Buy one for your loved ones. It's amazing how quickly you lose the ability to think, and your instinct is to go to sleep. Helen and I were both in the building, and it was a scary thing. And the worst part is you feel like you have a hangover for the next 24 hours, but not a normal one, the worst one you've ever had, allegedly. Not that I've ever, had a hangover. So really encourage that. The other is the reason this presentation got rescheduled had to do with a family emergency that I had, and everybody is okay. So we'll start with that, but it had to do with heart issues, and they were detected as the result of a cardiac scan, which is not covered by insurance, but is a very cheap procedure. It's $200, I think, is what it is. And it identifies calcium buildup on your heart, which can help identify widowmaker type heart attacks. And so just highly encourage you to do those once you get to, our age, 29 and older. But
full service today. We're providing all sorts of that.
We really are. So my first prediction is everybody who listened to this webinar is going to be safer and healthier next year. So with that, let's go ahead and get started. First of all, let's go ahead and introduce ourselves.
Sure. I'm Helen McMurray.
And I'm Lisa Messner.
And I'm Michele Shuster, and we are all partners at McMurray and Shuster. And this is something that we do annually. We have our doorbell. I think that we were not meant to give our predictions webinar, but our market prevail. We will prevail. We are going to get through it this time.
They call them great spirits, apparently. Here,
apparently the crystal ball was not a good omen for us for this. Anyway, so we do have a question and answer box in the chat. So if you have any questions that come up throughout this, don't hesitate to put those in the chat box, and we'll try to get to those before the end of the session. If we don't get to it before the end of the session, then we'll follow up by email with the responses. The webinar is being recorded, and it will be available on our website, mslawgroup.com, a few days after the webinar. So feel free to go back and look at it or share it once this is over. And then, as always, the legal disclaimer that while we are attorneys and we are going to be talking about legal issues, we are not providing legal advice. And it's really critical, based on your own factual scenarios and situations, that you do get legal consultation for these important matters that we're talking about today.
And to answer the chat question, there's no body lying out there, so we're assuming that the person who tripped in the background is okay.
Oh, at some point you just have to laugh. It's been a humorous several weeks for us. And it actually hasn't been humorous. We've decided to make it humorous. So let's start off. AI is one of the things that we're going to talk about for next year. And I'll tell you, I did go to ChatGPT 3.5 to look to see what its enforcement and compliance priorities from state AGs and federal regulators, what it anticipated would be next year. And I'm very happy to report from a job security position that they said that they cannot make predictions into the future. So we are providing a service that artificial intelligence is not capable of doing. But what it did say, which I will say is accurate, is that to understand what's going to happen next year, you really have to understand what type of statements the regulators were releasing this year, what we saw happening in the courts this year, and what we've heard as far as announcements go. So ChatGPT did provide that advice, and I would say that is very important advice. And it also did know enough to know that it would focus on fraud prevention, data privacy, consumer education, fair business practices, and addressing emerging threats in the marketplace. And that is as it has always been with consumer protection, going back to our days as consumer protection chiefs in the AG's office. So with that, let's go ahead and talk about what on the executive level has happened with AI. We haven't seen any bills that have been passed. We did see about a half a dozen that were introduced in the States. Generally, they're talking about the reliability and ensuring the reliability of artificial intelligence, making sure that the systems have checks and balances, that the information that's being provided isn't going to cause harm or have inaccuracies. So having those types of built-in checks and balances, and then also making sure that any type of information that it's provided based on the information that it's being fed isn't discriminatory in any way that would violate the law. So that's what we see the states kind of focusing on with their state laws. I anticipate or that were introduced, legislation that was introduced that not passed, but I do anticipate that we'll see a lot more of that in 2024. But going to the executive order, President Biden, when he released his executive order, what he was doing was he was providing direction to the administrative agencies in the federal government as to what he wants to see in those administrative agencies for their priorities for artificial intelligence. And so, obviously, one of the things that they want to focus on is making sure that the users have safety and security as they're using those and using artificial intelligence applications. And so that's going to reflect on privacy and making sure that any privacy concerns are addressed, and also making sure that there aren't any of those discriminatory algorithms that are being used. The president does want to promote innovation, and he wants the United States to be one of the leaders in artificial intelligence. I think that makes perfectly good sense, and I think we'll see strides for that next year. Also, job training was something that he stressed. I gave a presentation earlier this month, and one of the things that we had used was a video that showed a woman who was applying for a position to be an artificial intelligence search or query specialist. And the job was high paying. It was something like $250,000. I mean, it was a little bit insane, I thought. But it is interesting to see how it is going to require special skills moving forward to be able to use artificial intelligence to its greatest efficiency. So he wants to focus on job training. Also, privacy, closely monitoring any use of AI, and then also making sure that, as I said, that they're a global leader in artificial intelligence. So I anticipate we'll see those strides moving forward in 2024.
One example, I'm going to be talking a little bit later about the CFPB, the Consumer Financial Protection Bureau, and it has already issued a guidance to lenders who are out there using AI to make credit decisions. And it kind of gets back to what you were talking about with regards to discrimination. And they're just not going to be able to say, oh, I plugged it in and that's what it said. That's what it said. They're going to have to be purposeful about it so that they are ensuring through this guidance that credit denials do not violate the law.
Yeah, it's kind of interesting. Whenever we see these types of technology issues and the increase in technology, it all still comes back to the fundamental consumer protection regulations. So if it's something that would apply without the technology, then it's most certainly going to apply with the technology as well. So with that, moving on to self-regulation. I know a lot of industries out there have tried self-regulation as a way of stopping the storm of regulatory changes and legislative changes that are happening out there. I don't think we've had much success with that in the last year. I do see some industries that are kind of reorganizing themselves. The Insurance Marketing Coalition, I think, is a great example of that. I know that they are working on a self-regulatory organization. I have high hopes for that. But I would hope that we will see industry start moving more towards self-regulation, but I don't see a lot of that with the current associations that we have out there. So
yeah, it has to have teeth associated with it, and that affects bottom line. And when the economy is not the best, then you don't really see a lot of acquiescence to that.
Yeah. Let's talk about a little bit about the state laws, and then I'll come back to CMS. So we had some mini TCPAs that took the spotlight this year.
Sure, actually, over the last couple of years,
Yeah.
really. So the post-Duguid landscape, if you will, spurred on the states to enact some of their own, mini TCPA laws, for lack of a better term. And we saw, I mean, Florida took the lead on it. That was the big one. And we saw an uptick in class actions filed in state court in Florida as a result, because that had a lot more teeth in that post-Duguid environment where the ATDS definition was narrowed. And then the states were turning around and expanding it out, and even adding additional heightened regulations. We saw it with Florida, Washington, Michigan, New York, Oklahoma. And in addition to that, more and more states are kind of following suit with just general consumer protection laws that kind of adopt TCPA violations under their umbrella and allow attorney's fees to be recovered. So that had traditionally been the case in, for example, Ohio and Texas. Both have those types of laws. We're also seeing an uptick in, the adoption and incorporation of those laws to enforce telemarketing violations.
Yeah. What about privacy, Helen?
Well, busy. Over 350 bills in 40 different states were introduced this year. About a dozen of them passed, and a mixture between red and blue states, so not necessarily all in the blue states. Also, about a half a dozen that either had states that had no bills introduced whatsoever, or they just sat there. So you don't have the whole country moving to pass these laws, but obviously a significant amount, and a lot of people are looking at it. Our prediction, crystal ball, for next year is, we're going to probably see very similar types of things. I think we talked a little bit about the AI element of it, but we predict probably about a dozen new laws will be enacted throughout the country. About half a dozen of them will be general privacy laws. Probably another half a dozen will be industry specific or topic specific. And we're really thinking that healthcare is going to be, really punched up in terms of the privacy there, with some issues that have occurred throughout the year. And that's going to be the primary area where we're going to see not only laws protecting it, but then private right of action, we think, is going to start popping up in those areas, because they've already had some of these laws, they're just not being complied with. And that's when we get to see justification for a private right of action, which of course then brings on the potential for class action litigation, depending on how the statute is written. So continue to be busy.
Yeah, I agree. It'll be interesting to see what happens with the FTC in 2024. They have put out, put together programs to obtain more information about how they can interact with the privacy landscape. We did see in their budget for last year that they had asked for significant and had received significant increases for staffing. And we're specifically citing privacy as one of those reasons. So it'll be interesting to see if the FTC is going to be able to step into that arena. I think that everybody who's marketing out there and marketing in all 50 states understands the difficulty with the various privacy laws. They're either taking the approach of complying with the most onerous or taking, there's basically two different styles of privacy laws out there, and complying with both of those. So interesting to see. And as much as we would like the FTC to preempt this area, I think that would be a very difficult thing. And I don't predict that happening in 2024 or any federal legislation in this area, given that it is a presidential election year. So I think states are exactly as you said, is what they are. On the CMS front, with advertising for Medicare and Medicare Part D programs. There was an announcement that was, or a proposed order that was released by CMS, where they had proposed several changes. And mostly those are around prohibiting contract terms that would influence a marketer to recommend one plan or one policy over another, based on the incentives they would be receiving through those contracts. So I think that one of the areas that we'll be looking at in 2024 is how contracts are drafted and what the compensation provisions look like, to make sure that they will comply what we think is likely the new rule that would be in effect before the open enrollment period next year. So continue to monitor CMS. Aaron Perry from our office has been very active in that area and always happy to talk to folks about potential changes there. Moving on to the robocall task force. The robocall task force, I'm sure most of you have heard about the state attorneys general in cooperation with the FTC and FCC, but have put together what's called a robocall task force. And the purpose of that is to shut down illegal telemarketing operations. And they have been very effective at coordinating their efforts, working as a group to issue subpoenas over the last 2 years, really. And we expect to see much more of that moving forward. I know one of the areas that the attorneys general are focusing on is how can they get jurisdiction over the voice service providers or the intermediate telephone carriers so that they can take a more proactive approach to stopping the initiation of illegal robocalls at the technology or the telecom source. And so I think that we will see a very emboldened robocall task force next year based on what they had as some very successful results in 2023. And I do see them focusing more on those kind of service providers and telecommunications providers moving forward.
You know, Michelle, here in Ohio, you know, we saw the Ohio Attorney General, which is very prominent in the task force, you know, look at a different third party in terms of administrators of vehicle service contracts who aren't calling anybody, and they work with all sorts of different marketers. And the Attorney General has either settled with or has, in our client's case, unfortunately, sued, claiming that the violations should flow through and they should be responsible for them as well. So continuing to find jurisdiction wherever they think they may have it.
Yeah,
You know, we fight it, quite strenuously against it. So
yeah, and liability up and down the chain. I mean, we're seeing more of that, and as I said, the courts are allowing it. Settlements are happening that include those types of provisions. So I think we'll continue to see more of that in 2024.
Even for the platform providers too, it's going all the way up and down chain.
Yeah, for sure. Okay, taking a drastic change in direction here from our cannabis practice area. And Ohio has been at the spotlight recently about cannabis with the passing of a recreational marijuana. So what do we see happening in 2024?
yeah, well, I think that Ohio, especially as a red state, that was really truly opposed to it from our legislative perspective, with it being a very Republican legislature. The populace took the power in their own hands and voted, quite loudly with regards to saying that we want to have adult use cannabis in Ohio, and for a multitude of reasons. And we're now seeing that once that passed, it's actually now effective. So home grow provisions are permitted as well. And then the Department of Commerce, which is going to be taking over complete control of the program, they're really on it, and they are looking at it from the perspective of, we want, if this is the way the law is going to be, we want it to be safe. We had an alert this weekend for another one of the fentanyl that gets into the illegal marijuana that's being sold, and I think we lost a half dozen people died of overdoses this weekend just in central Ohio. And so the governor, I know, has really taken to having press conferences to talk about, now that we have it, let's use it as a tool to help fight the opioid addiction. And when you have a Republican governor, the prominence of Mike DeWine, then I think other red states were going to take a look at that, especially if they know that they might be facing ballot issues like you did here in Ohio. Our ballot issue in Ohio wrote the statute. It wasn't a constitutional change like you see sometimes. So I really think that red states are going to be looking at that more carefully, seeing what the result is. Is this going to really help with regards to illegal marijuana, those folks going and purchasing from a recreational perspective and a legal perspective. I don't know that there's any other states out there that are really talking about considering it right now. So I don't really foresee a great amount of legalization continuing in the other half of the states here in the United States. But there are several markets, Illinois, New Jersey, that are just Pennsylvania, they're just not working well at all. And so they really need changes in their legislation. The taxing issue is huge. It's difficult for these companies to make profits with some of the tax scenarios that are being set up. And everyone is waiting for the Biden administration in these last, year or so, to go ahead and to declassify this as a drug and really turn the tide. But if it hasn't happened so far, my glass ball doesn't say that it's going to happen anytime soon. It's going to get us detract away too much from the other presidential issues.
Well, you said that the president in his last year, are you predicting he isn't reelected?
I am predicting that Biden is not going to be reelected.
All right,
There are many reasons how that could happen.
Mark at the 120 minutes
Okay,
time
yeah,
frame. We'll
yeah.
bring that back after election next year. All right, so CFPB, Helen, what's going on with the CFPB? What can we anticipate next year?
Well, the question is will the CFPB be here next year? Okay.
Right.
And the crystal ball is saying, unfortunately, yes, it will be. And the reason why it would not be, for those that don't keep up with this, is that the US Supreme Court is going to be deciding a case, Community Financial Services Association of America versus CFPB, where the association successfully in the Fifth Circuit found that the CFPB was unconstitutional. And in that particular case, because of its funding mechanism, it does not get funded directly from Congress, as well as not meeting the separation of separation of the government branches. And the US Supreme Court accepted cert on that. And so the oral argument was in early October. And so we will be getting a decision probably in the first 6 months of next year. And generally, the US Supreme Court doesn't do anything the way you think it's going to. It doesn't frame the issues the way you think. I mean, they always come up with a surprise. And so I don't think that they are going to make it go away forever. But I do think there are going to be some very serious ramifications if it is found unconstitutional. Now, we have clients that are sitting in the Ninth Circuit waiting on this case. And we want them to say that they didn't have the authority to bring prior enforcement actions and take many millions of our clients' dollars that the court awarded. And the court for example, when it found that the way that the director was picked and found that unconstitutional, it did not take away those enforcement actions. But this is talking about the foundation of the bureau, so it's a little bit different than just the person who leads it. So I think that there's more of a chance that will happen. And then there's also the issue of what will happen to all of the rules that have been adopted by the CFPB and how will they be impacted. It certainly is not slowing the CFPB down. They actually have a proposal right now to expand their authority. Okay, they now cover a great majority of the banks in the U.S. and now they want the non-bank financial institutions, the Venmos of the world, those types of things, to also come under their authority. So they're never one to be shy. They are continuing to be aggressive and and keep going as long as they can. So I think we're gonna find a judgment that's going to be somewhat in favor of the association that has brought suit, but I don't think it's going to give us the complete wipe it off the face of the earth result that a lot of people might ask for.
Do you think that if the Supreme Court does come down and finds that the funding violates the appropriations clause, that Congress will just fix the funding mechanism?
Think how hard it's going to be, right? I mean, they can't agree on anything. So it's like with the TCPA. I mean, we've had these problems for how long, Michele? We've been chasing these problems for literally almost 3 decades now, right? Back when we were at the Attorney General's office, we first started working on these issues. It's not going to happen soon. It's going to leave a mess. I just hope it doesn't leave a bunch of private sector companies, people like our clients, I know, just kind of hanging there, and we'll give them an actual remedy that they need and they deserve, quite frankly.
Yeah. I know that the CFPB this year also was most focusing again on the service providers that the financial institutions are working with, and probably in the late around 2018, 2017, they were issuing a lot of civil investigative demands to voice service providers and other marketers with financial institutions. It kind of sounds like they're going to be heading in that direction again.
Well, I think that they're pursuing this avenue of where all the different prongs go and putting pressure everywhere. And that has frankly proven effective at moving change in some of these industries. And where the industries have not moved enough, I think they're going to absolutely continue to do that, if not turning up the heat even more.
All right. So that takes us to the FTC.
Yeah, FTC. So there was a big decision that had come out in the fall of this year, the Indiora case, and it really kind of had pretty rippling effects, I think, across the direct selling industry. So Neora is a company that is a multi-level media company, and it sells different kinds of beauty products, skincare products, things of that nature. And so in the context of the way that they have it set up, the agents who sell and distribute the products are called branding partners. And most MLMs have some kind of, name for their consultants. And in that case, it went to a bench trial in Texas District Court on only the issue of injunctive relief, because the court had actually granted a judgment on the pleadings based on the request for monetary damages based on the AMG Capital case, which prohibits award of money damages under Section 19 of the FTC Act. Now, make no mistake, the FTC's figured out creative ways to get around that to still make sure that they can obtain monetary relief. But in this case, the only issue before the court was injunctive relief. And what they had essentially premised the FTC's case on was this notion that that the agents were enrolling and not really, receiving any kind of benefit.
Right.
And so, I mean, that's the crux of it, right? But interestingly, Neora had all of this expert analysis and sales data to show that many of its branding partners actually wanted to be branding partners solely for the benefit of getting discount on the products that they liked. And the judge latched onto that. And it was interesting. She had a really good quote in finding that this data emphasized a benefit to the branding partners. She says, put differently, we may walk away poorer than we started after a trip to the grocery store, but because we obtained valuable goods or services in return for our money, that exchange is not characterized as a loss. And so, there was a lot of chatter about this ruling and what that may mean for the FTC's ability to get injunctive relief in these types of cases and in the direct selling market. I do think that it is going to impact how negotiations go with the FTC in cases. And I do think that it is going to impact how they attempt to obtain injunctive relief going forward. But I also would caution that with the FTC is creative. They may have made a blunder in this case, but you can expect them to be creative and figure out how to, still obtain injunctive relief. So, obviously compliance is still important and things of that nature, but it definitely is going to really impact the ability for direct sales to operate.
Well, talking now about the FCC, which has made quite a splash this month with the releasing of their order in their open meeting last week that was kind of a subtitled closing the loop or the lead generator loophole. Through that order, one of the things that they did, they wanted to make it perfectly clear that text messages are also covered by the TCPA. I think that we have always advised our clients that text messages are calls. You should treat those as if they are calls. The one thing that I will say by the FCC saying that they are now saying unequivocally that text messages are covered by the TCPA. I think there could be some opportunities for cases that are pending alleging TCPA violations based on text messages. And so I anticipate we'll probably get some pushback in court around that as a result of what the FCC has done and said in this order. But the most talked about development in the FCC order is this concept of one-to-one consent from one consumer to one seller. And obviously, I'm sure unless you've been sleeping for the last week, you've heard all kinds of pundits and commentary around this. But basically, at the heart of it, it is going to require consent be obtained for one seller at a time. And we're talking about prior express written consent under the TCPA. And that's the type of consent that you need to use an automatic telephone dialing system or to call cell phones, or a pre-recorded message to call cell phones, and in certain circumstances, landlines as well. And so in those circumstances, those age leads that did not specifically identify an individual seller that the consumer consented to, or the shopping comparison sites that the FCC referenced a number of times, or any of the leads that were generated using a marketing partner link that linked to many potential sellers that would be, or sellers that would be potentially calling. And so this has struck a significant arrow in the heart of the performance marketing space. But I've been talking to lots of clients and lots of companies out there that are already figuring out creative ways that they will still be able to operate in a profitable way within the FCC's order. Also, another interesting aspect of that ruling is that the FCC specifically called out the e-sign act, and they did that back in 2012 when they removed the existing business relationship exemption for calls using an ATDS or pre-recorded messages. And so the interesting thing about it is, in that original order, the FCC had specifically referenced that you could obtain e-sign consent through a recorded message or through electronic signature, websites, through an affirmative consent, those types of things. Now, in this order, they went a step further and they said, and additionally comply with all of the other e-sign requirements. And so that's got a lot of folks scratching their heads saying, well, what does that mean, complying with all the other e-sign requirements? Because, depending upon what type of documents you're talking about and which law that you're complying with using e-sign, there could be several different requirements. This is one of those areas where you definitely want to make sure that you are getting your lead generation forms looked at, because I can guarantee you, this is my prediction, I guarantee you that there will be a lot more cases filed by class action attorneys, vexatious litigators around whether the proper e-sign procedure was used to get consent. I think that is going to be specific to the type of consumer transaction that it's ultimately going to be related to. I do think also that at the heart of this, we are talking about prior express written consent. And I think there are ways that you can do that through specifically consenting to e-sign, consent for and then consent for TCPA, and maybe terms and conditions and privacy requirements as well. But I think it's going to be really important to have all of that built into your consent form moving forward to avoid all of the litigation that's going to happen.
And making sure that you keep the evidence of it. I mean, we've got a number of cases where a third party, came in and provided all these wonderful disclosures, and then 3-4 years later in litigation, when we needed to pull them up, they weren't around anymore. And, the third party vendor really hadn't disclosed that up front. So that's going to be something you're going to need to make sure that it's in your contract, or that you confirm that it's going to be held on. I mean, they can argue the statute of limitations, depending on where you are, up to 6 years.
Yeah.
That's a long time to hold a whole lot of data.
Yeah.
Is there any appeal to this, Michele, or are they stuck with it?
Well, just one thing on that, I will say, the FCC order did say that sellers are responsible for keeping these records. So they made that abundantly clear in this order. And so we are hearing from a couple of groups that are looking at filing an appeal of this order. I have heard that some are thinking about filing a stay as well. As far as the effective date of this order, it's 6 months after it's published in the Federal Register. So the FCC, I think, realized that this was a significant development that was going to take time to adjust to. I would definitely anticipate an appeal. I don't know how effective a stay will be at this point. But, the last time we went down this process, we were successful with that, and ultimately ending up with the FCC's 2015 order being overturned, which was a wonderful thing.
He thinks it's a year.
Okay, so the FCC, I will tell you, I have not looked at the FCC ruling that was published yesterday. And so I am not going to be able to speak to that. I apologize. I was in meetings all day yesterday and this morning. But I would, Scott Gilman, thank you, always a friend. He's saying that now the order says a year. So thanks for that, Scott. And we will be getting information out about the order that was released yesterday. So look for a post on our News and Insights page that contains our blogs on our websites that'll be there. Jason also saying he's heard the date is 12 months. So thank you. This is the wonderful thing about the people that come and listen to our webinars. They are some of the most educated people out there, and we appreciate that. So stay tuned for more on that.
And it just speaks to the difficulty that the agency is going to
Oh,
recognized
Yeah.
for people to come into compliance with
Yeah.
that.
well, I mean, we also represent some smaller companies, that they're like, hell, they can't do this.
Yeah.
This ruins our business model, and, obviously we'll do everything we can to try to make this as less impactful. But at the end of the day, you all survived before any of this type of marketing was done, and you're all brilliant and creative, and you will go, we'll find something new to replace it. But certainly, listen to what Michele is saying, doing that, getting those plans in place now is critical, so you have an alternative. And who knows, maybe it'll even be better with
I love,
AI
I
help.
love your, my
Yeah.
prediction is Helen will be optimistic
Yeah.
next year. So, let's see, do we, enforcement, we're gonna go through enforcement, then we'll get to some of the questions that we're seeing, come up.
Yeah.
Lisa is the head of our, litigation practice area. What are you, anticipating as far as, litigation and enforcement goes next year?
Yeah, I think, TCPA is gonna be at the forefront. And we're gonna see, uptick in state laws, obviously. It's interesting because in 2022 and 2023, we saw, the vast majority of TCPA cases were filed as class actions. I think in 2022 was something like 69% of all were that, and it's maybe up over 70% now. So the vast majority of these cases are filed as class actions, and just where the damages are statutory, they're not discretionary or anything that is kind of a cushy, compensatory type of award. It's just statutory. The volume and the liability is huge. We're seeing some, trends that are focusing certain industries. Real estate's probably the big one. And there's even been a trilogy of cases this year that have held that companies looking to acquire real estate might actually be covered by the TCPA requirements. And traditionally, those were industries thought that, to be exempt because they're looking to make a buy, not make an offer to sell something.
No doubt due to the text messages we're all getting, asking to buy our properties left and right.
Yeah. And so, those are kinds of things to watch for. Another industry that I saw last year be targeted was car dealerships. Because it's very easy to just go into your CRM, pull out data, for example, people coming out of leases or people who have purchased a car 2 to 5 years out, might be looking to trade. It's really easy to gather that data and then just in mass text or do whatever.
Well, I think, car dealers, kind of like what we're seeing in cannabis is that, that they've got this deck of customers. And well, of course I can reach out to it and let's do a texting campaign. And they're just not realizing that they haven't gotten the proper consent. They haven't followed the rules, that they could then be, victimized by these class action lawsuits, which we've seen in, not only car dealers, but also in cannabis. So.
Yeah. And even for the car dealers, they're going to be impacted by some of these rules because I've seen it oftentimes that they'll rely on financing documents as for prior express written consent. Well, that's going to go away because that consent is extended to the lender and not to the car dealership. And then the last one's insurance. I saw a lot on the insurance front, and I think that that's another industry that's really going to be impacted by the one-on-one rule, because you're going to be able to extend to different kinds of agencies or different kinds of branding within that. So those are the trends really I'm seeing in terms of industries being kind of targeted just by rulings that happened last year. And I think going into 2024, because of some of those rulings, we'll continue to see an uptick in those types of cases. And I think that 2024 will be an all-time record high for TCPAs to be filed as class actions.
Henry's asking about political calls and polling calls. Are you seeing a lot of that now? Do you think that's going to grow next year with the presidential election year?
It will, but those are largely exempt.
Yeah.
So I would not anticipate seeing litigation in around that. I mean, the politicians are going to make sure that they exempt themselves. So I think that those are largely going to be exempt.
And the only thing I would say about the political calls is, that certain types of political calls would be covered, so obviously pre-recorded messages and those types of things. You're still going to need prior express consent. And I think that sometimes the politicians can get a little reckless with their campaigns. I think we saw Donald Trump sued. I think we saw President Biden sued for text messages and pre-recorded message phone calls. I anticipate that there'll be a little bit of political party type of effect maybe on who gets sued there too.
And remember, if you're using a professional solicitor for these types of calls, then the rules are different.
Yeah,
that's
You
true.
know, so you gotta, if you're calling from the campaign, from the actual political party, that's one thing. You hire a third party who's for profit and it changes the rules.
Good point, good point. All right, so let's see, I think we've covered all of our topics. We can get to some Q&A now. Lisa, number 4, I think, was kind of targeted, if that's something that you want to address.
oh, yeah, so the question we had posed was, how and why does T-Mobile have the ability to shut down SMS capability on a registered number, sending notifications to opted-in customers without any due diligence? The quick answer is because the FCC says so. You know, essentially this has, you know, in and around all to do with trace back and those types of things. And so, you know, the carriers just have the ability to do it.
Yeah, they certainly do. And they just have to have a reasonable belief there to be able to do that. And they've got a safe harbor. So they're feeling pretty emboldened to be able to do those types of things. Okay, a lot of these we've already answered. Let's see what we've
I
got
can
there.
answer that one about investment and investing while you guys are looking at those. Those some questions were sent before. You know, so we're seeing a lot of enforcement actions in the investment area where people who are not registered brokers of securities, particularly gold and silver dealers, for example, are being the issue is being investigated by regulators at the state and then at the federal level. And so I think that as more different types of investment tools are allowed to be going into your IRA, and the disclosures are not always particularly effective, much less clear and conspicuous, and people are having monies moving from their IRA and then having a whole lot less in their new accounts, that is going to be very problematic. And so we're seeing that got investigations on the state level. We've seen a couple of big multi-state lawsuits with different federal agencies on investment and investing calls. So that's for the substantive side of it. You know, all of the laws that we're talking about here are going to apply to these types of calls and texting as well. And so, you know, that all of these predictions are going to apply to the investment area as well. But the more you're claiming to be an investor and broker, you know, then you're just invoking a whole lot of other laws that require you to be registered in a lot of states and with the SEC.
One of the things we were asked to address was the state laws that are more restrictive than the federal laws. You know, we often give advice on how to comply with the TCPA and the TSR. And then we also want to address those states that have more restrictive laws than what's contained in those federal regulations. And Arizona and Connecticut, you have to give consent to call a consumer's cell phone, regardless of the type of technology you use. So something to pay attention to. In Florida, if you have the type of consent that you need for calling, including with pre-recorded messages, or their definition of an automatic telephone dialing system, which was a little wonky starting in 2023, but then was corrected. And that had to do with states that have provisions that regulate the automatic dialing of telephone numbers using a system that can, okay, I'm totally messing this up. Let me start over again, but that automatically select and then automatically dial a telephone number. And so in Florida, they had the automatic select or dial the telephone number. That's an and. But as I think you might have even mentioned, Massachusetts and Oklahoma are still under the old, more onerous provision. So you want to pay attention to that. And in Florida, as I said, after 18 months, consent must be renewed. In Louisiana and Wyoming, you have to have consent or an EBR to call a consumer's cell phone. So a little bit different than the federal. And for New Jersey, you have to have consent to call non-customers' cell phones. So again, more onerous to call cell phones there. In Texas, you have to stop calling if you're informed that the person you're calling is charged for that telephone call. So those are some of the state regulations. Also with call frequency in Florida, it's 3 marketing calls within 24 hours on the same subject, so no more than 3. In Maine, it's 1 call within 8 hours using an automatic telephone dialing or calling system. In Maryland, it's 3 calls within 24 hours on the same subject or issue. And then in Oklahoma, 3 calls within 24 hours also on the same topic or a matter or issue. So, we talk all the time about the TCPA, but it's important to remember that for state calls that there are some that are more restrictive, and I anticipate we'll see more of that in 2024 as more states are introducing regulations. A lot of the state legislators, their terms end about mid-year, and all the legislation that have been introduced is put aside and it has to be reintroduced at the beginning of the year. So we'll see, I think, a huge uptick at the beginning of 2024 about those types of things.
Brad wants to know if we have to throw out all those leads he bought under the old system.
I don't know what kind of old leads you bought, Brad, but we're happy to take a look at those for you. But I would assume yes, especially if you're looking for consent to use an ATDS under the Telephone Consumer Protection Act, an automatic telephone dialing system or pre-recorded messages, you're going to need one-to-one consent. We haven't really talked about the prior written consent that's required for calling telephone numbers that are on the do not call list. But I think that's something that there's a lot of controversy and differing of opinions as to whether that one-to-one consent requirement applies also for do not call. And I think there is some kind of dicta in the FCC's order that implies that it always has, which is alarming because that's not something that's going to change moving forward like the prior express written consent. But I anticipate we'll see a lot of litigation around the type of consent that's required for calling folks that are on the do not call list without an exemption. And one thing I just wanted to put in here is that we've gotten a lot of clients that have had they became our clients, I should say, when they ran into trouble with Wisconsin. So if you are scrubbing the Wisconsin do not call list through the Federal Register, so you would have a SAM that included Wisconsin numbers, Wisconsin is looking at that. And if you are not registered in Wisconsin, then they are initiating regulatory action. So they're getting very active right now. So pay attention if you're in Wisconsin and make sure that you are meeting all those regulations. That it's the Department of Agriculture and Consumer Protection, DATCAP. They are being very, very aggressive and feeling good about this new.
So what about AI? Mark's talking about, can I use AI to call? That's not a pre-recorded message, is it?
So under the TCPA, it regulates pre-recorded or artificial voice, and the courts are uniformly finding that artificial voice includes AI. On the state level, you really got to look at those state regulations to see what they're regulating. I would start with the assumption that AI is regulated the exact same way as all pre-recorded messages. And then if you want to spend some time really diving into those state regulations to see if you have some colorable arguments that could happen. But again, you're going to have to most likely comply with the TCPA anyway. So you should consider AI a pre-recorded message to stay safe in 2024.
Yeah, we saw it with Soundboard.
Yeah, exactly.
Yeah, exact same thing. All right, we have a few more minutes here for a couple of calls. All right, a couple more questions, I should say. Let's see. What are the best practices for managing calling back an inbound consumer initiated call that goes unanswered? This is probably one of the longest running questions that I've gotten asked in my legal career. What can you do if somebody is calling inbound, but then hangs up before you have an operator to answer that telephone call? And the question is, can you call back? And so the answer to that question is, if you are calling for telemarketing purposes, so the purpose of that return call is going to be to sell products or services, which most likely it would be, which is why you're calling them back, then you need to follow all the consent requirements that we've been talking about during this webinar. Some things you could do, maybe if this is within the scope of how your business could operate, maybe have a voice message that would be capable of taking the information of the consumer and allowing them to ask you to call them back. And then that most certainly would qualify as an inquiry existing business relationship, which would be an exemption from the do not call requirements. So I think there are ways you can do it. You can get creative, but just blindly calling back a telephone number from caller ID is not a recommended good practice. All right. I think we've gotten through the questions. If any more come in, we'll certainly answer those either directly to you. We will also be blogging on some of the recent activities that happened even as within the last 24 hours, always staying on top of those types of things. Thank you so much for spending this time with us this afternoon. If there's anything we can do to help you, don't hesitate to reach out to us.
Yeah, connect with us on LinkedIn. We are out there all the time trying to share information with you or provide it from our blogs if you don't have to check into our website all the time. So we'd love to have you.
So happy holidays.
Happy holidays.
And prosperous 2024.